This program is brought to you by Emory University.
Okay, I hope everyone had a good break. We're able to stretch their legs and discuss the fascinating topic of tuition clawback, but I think we have something equally, if not more fascinating, right now. This year, at our 16th Annual Symposium, I am delighted to introduce our first ever keynote speaker. But in doing so, I'm struck by how lucky the Emory Bankruptcy Developments Journal is to hear from Judge Deal. The Honorable Mary Grace Deal is a retired bankruptcy judge serving on recall status. She served on the Bankruptcy Court for the Northern District of Georgia from 2004 to 2018. Prior to that time, she was a partner in charge of the bankruptcy group at Troutman Sanders. Judge Deal is a fellow and former vice president of the American College of Bankruptcy and served as president of the National Conference of Bankruptcy Judges in 2016. She has also served in leadership positions with the American Bankruptcy Institute, Turnaround Management Association, and the International Women's Insolvency Restructuring Confederation. She is a 1977 cum laude graduate from Harvard Law School. It is my great honor and distinct privilege to introduce Judge Deal, and I hope you will all join me in welcoming her. Judge Deal.
Okay, Mark told me to talk about the last 40 years, and so we're going to go back and pretend it's 1979. I'm a second-year associate at Troutman Sanders, Lockerman & Ashmore, one of Atlanta's largest law firms. We have 70 lawyers. I'm a member of the litigation section, one of only 3 groups at the firm, the others being corporate and real estate. There's no bankruptcy or restructuring group. Our pleadings are typed on legal-size paper using state-of-the-art IBM Selectric typewriters. All communications with clients, colleagues, and adversaries are in person, by landline telephone, or the U.S. mail. There's no voicemail, no email, no text messages, not even faxes. The Bankruptcy Court for the Northern District of Georgia is located at 56 Forsyth Street, the present home of the 11th Circuit Court of Appeals. Of course, in 1979, there is no 11th Circuit. We're part of the 5th Circuit, headquartered in New Orleans. We have 4 bankruptcy judges who have only recently gained that title from their prior status as bankruptcy referees. I'm quite sure they did not have law clerks. And the law we're dealing with is the Bankruptcy Act of 1898 as revised by the Chandler Act of 1938. I know all 4 judges because they preside at the first meetings of creditors in cases. One of my assignments as a young associate was to represent Georgia Power Company, and I had to go and ask at the 341 meetings about the electric appliances they had financed for their customers. So I had asked, where's the washing machine? What condition is the dryer in? How's the refrigerator doing? The bankruptcy judges were required to listen to these questions and the answers. The judges also presided at discharge hearings, which were held in every Chapter 7 case, where the judge guided debtors through the meaning of their discharge and passed on reaffirmation agreements. By the end of 1979, a lot had changed. The Bankruptcy Code of 1978 became effective on October 1, 1979. It was the result of the recommendations of the Commission on Bankruptcy Laws created by Congress in 1970 and then modified in certain ways by a competing proposal from the National Conference of Bankruptcy Judges. At the end, the 3 main corporate reorganization chapters of the Act, Chapters X, XI, and XII, had been merged into one, Chapter 11. Large corporations, which had previously been forced into Chapter 10 with its mandatory trustee appointment, were now able to remain as debtors in possession. Other business debtors who were unable to modify secured debt in the old Chapter XI were now empowered to do so. Chapter 12 for real estate reorganizations disappeared and was also part of Chapter 11. Excuse me. From the bankruptcy lawyer's perspective, the code shunned the miserly fee standards which had been typical under the Act. Bankruptcy lawyers could now be compensated at market rates. It's no coincidence that major law firms got into the bankruptcy business, particularly on the debtor side as the code unfolded. I was young and inexperienced at the time, but those who were more seasoned with bankruptcy law tell me that the original 1978 code was a masterpiece, balancing the rights of debtors and creditors and fostering real business reorganizations. Our own Judge Homer Drake was instrumental in designing the statute, and George and Jimmy Carter signed it into law. On the consumer side, the biggest change in the bankruptcy code was its approach to Chapter 13. The new Chapter 13 provided for all debtors with regular income, as opposed to only wage earners under the old statute, and removed the necessity of obtaining creditor approval of Chapter 13 plans. Can you imagine creditors voting on Chapter 13 plans? The only real legal standard the plan had to meet was the best interest of creditors test, meaning creditors had to receive as much as they would in a liquidation. And secured creditors could be crammed down to the value of their collateral, except for home mortgages. Chapter 13 also resulted in a super discharge of all debts except alimony and child support and long-term debts. All chapters also now included an automatic stay, which had previously only been provided in a bankruptcy rule. The original unamended code did not last long. Lobbying efforts by various groups and changes in the financial structure of our economy resulted in periodic amendments. We have the United States trustee system everywhere except North Carolina and Alabama. We have a permanent Chapter 12 for farmers and family fishers. We have Chapter 15 for cross-border cases. We have added protections for intellectual property licensees and shopping center owners, and specialized provisions for dealing with collective bargaining agreements and retirement benefits. There are broadened protections for the commodities and securities markets. On the consumer side, Congress changed Chapter 13 to mandate that a debtor commit all of her projected disposable income to the plan, in addition to the best interest test. The super discharge became less super as time went by, and additional exceptions were added. Similarly, additional exceptions to discharge and dischargeability crept into Chapter 7. The bankruptcy system also survived a constitutional crisis following the Supreme Court's 1982 decision in Northern Pipeline versus Marathon Oil, which questioned the ability of a non-Article III bankruptcy court to decide certain issues. A 1984 amendment clarified the role of the bankruptcy court and designated certain matters as core and non-core. This fix worked fine until a similar issue emerged in Stern v. Marshall in 2011, where the Supreme Court looked to define the constitutional limits of the entry by the bankruptcy court of a final order in certain matters designated as core in the Judiciary Code. It took two more Supreme Court cases, executive benefits and wellness, and the adoption of rules dealing with the concept of consent for the system to breathe a collective sigh of relief and pretty much return to normalcy. Another bankruptcy commission was created in 1994. Its report was issued in 1997, and 11 years later, a number of its suggestions were incorporated into the Bankruptcy Abuse and Consumer Protection Act of 2005, commonly known as BAP-CIPA. While technically an amendment to the Bankruptcy Code, BAP-CIPA fundamentally overhauled the consumer provisions of the Bankruptcy Code, and while not quite as extensively, altered business reorganizations as well. BAP-CIPA made business reorganizations more difficult in several ways. It introduced an administrative priority claim for goods received by the debtor within 20 days of the commencement of a case, thus requiring payment of those claims in full to confirm a plan. The debtor's exclusive period to propose a plan was limited. The time for a debtor to assume or reject non-residential real estate leases was shortened, peculiarly affecting retail bankruptcies. The ordinary course of business defense for preference defendants was altered in favor of the defendants. KERPs, key employee retention plans, were curtailed, making it more difficult to retain the management force needed to effect the reorganization. The consumer landscape changed even more dramatically with the introduction of the means test for individual consumers who sought to file under Chapter 7. Creditors with interests in personal property, particularly cars, had their position strengthened as the debtor's ability to cram down was limited. The determination of projected disposable income was made the subject of objective rules for those above the median income of the state where they're filing. The Chapter 13 super discharge became even less super. Exceptions to the automatic stay came to fill 28 subsections of 362B. In many ways, the 1978 code became unrecognizable. These changes in the law since 1978 merely built upon the existing code without really taking account of the changes in the financial markets that have happened over the last 40 years. In 2012, the American Bankruptcy Institute undertook to study the reform of Chapter 11. Its report was issued in 2014. The ABI undertook a similar task for the consumer provisions, and its full report will be unveiled at the ABI spring meeting in April. The genesis of the ABI's corporate study was a recognition that today's credit markets, derivative instruments, and corporate structures are vastly different from what existed in 1978. Companies today have fewer hard assets and more services, contracts, and intellectual property. Moreover, businesses are much more highly leveraged, making financing a Chapter 11 case very different from what it was in 1978. Businesses today are multinational. Lenders are less likely to be traditional banks who retain their interests throughout the reorganization process, and they're more likely to be hedge funds or private equity who do not approach restructuring in the same way. Loan to own was not a thing in 1978. Holders of claims now frequently seek to sell their claims or are solicited to do so in an effort to influence the Chapter 11 process. Chapter 11 has also become too expensive for many businesses. This fact, combined with the shortened timelines and the increasing control exercised by the DIP lender as a result of market conditions, has made Section 363, the sale of property of estate, the reorganization plan of choice for well over half the Chapter 11s filed by operating businesses. It is a real tribute to the creativity of the bankruptcy bar that the Bankruptcy Code has been able to withstand these market changes. The code here, with respect to 363 sales, has no clear guidelines, and it's made for some very interesting lawyering and judging. The ABI's report on business bankruptcy is now 5 years old, and as we've said several times up here, no surprise, Congress has not done anything. Lawyers continue, however, to be very creative. We have horizontal gifting plans, we have vertical gifting plans, we have structured dismissals, we have chief restructuring officers being appointed even before the bankruptcy process begins. The ABI consumer study is focused on general consumer provisions and then specifically on improvements in Chapter 7 and Chapter 13. It will come as no surprise to many of the students in the audience that the first topic they have tackled is student loans. Historically, student loans were fully dischargeable prior to 1976. Of course, prior to 1976, education was not very expensive and borrowing was not as common as it was today. My total tuition bill for 3 years at Harvard was under $9,000. In the 1978 code, change was made to make government student loans non-dischargeable except for undue hardship until 5 years after the repayment period started. So after 5 years, the loan was fully dischargeable. That period was then extended to 7 years, and in 1998, the time frame was eliminated. In 2005, BAP-CEPA, the protections were extended to private student loans. The ABI Commission has published some preliminary recommendations in this area, which really amount to a bright line definition of undue hardship. The current expense of consumer bankruptcy filings is also a major problem. The complexities of the law and the landmines of the means test are pricing many would-be debtors out of the market and sending them to sometimes unscrupulous bankruptcy petition preparers or to make their filings pro se without the benefit of counsel. which makes for a very difficult experience for the court, the creditors, and the trustees. Considering that the earliest bankruptcy statutes in the 19th century lasted an average of 2 years, 40 years is a long, long time. As a profession, the practice of bankruptcy law is still an intellectually challenging one, and the bankruptcy bench and bar are the best there is. I hope many of the students will join the lawyers and judges in the audience in making the 1978 code, wounded as it is, a better and better statute, and will continue to explore ways to accord individuals and businesses who experience financial setbacks the fresh start they deserve. Thank you.